Welcome to Skin Deep here on Sirius XM Radio, channel 141, HUR Voices. I'm your host, Sharon Morton. And listen, folks, today I have one of my favorite attorneys on the show, Vernon Brownley. He's a lifelong resident of Prince George's County, Maryland, the richest Black county in the country. Attorney Brownley currently practices criminal defense law in the state of Maryland after serving several years as a prosecutor in Prince George's County. He now operates his own law firm where he exclusively handles criminal matters. Y'all know that having an attorney is crucial because they help protect your rights, navigate the very complex legal system, and ensure that you're treated fairly under the law. And for us Black folks in particular, having strong legal representation is vital in confronting systemic biases and advocating for justice and equity. Attorney Brownley has been a recipient of the top 40 under 40 trial advocates. He's certified in NHTSA field sobriety. We'll talk about that a little bit. And he's a member of the Maryland Criminal Defense Association. In his spare time, he enjoys spending time with his son and watching the Washington Commanders football team. Yes, we love the Commanders here on Skin Deep. So as I always say, we're going to be doing more than just scratching the surface. Here on Skin Deep, we're talking all about justice under the law. And by the way, if you reach out or want to reach out, you can email us at skindeepradioshow@gmail.com. Stay tuned. We'll be right back after these messages with information you just can't afford to miss here on Skin Deep. Welcome back to Skin Deep here on Sirius XM Radio. As I mentioned before the break, I have attorney Vernon Brownley on this show. He practices criminal defense law in the state of Maryland, and he is here to give you some advice on the importance of having an attorney when dealing with the justice system. Welcome to the show, Attorney Brownley.
Thank you for having me. I'm greatly honored and privileged to be here today.
Yeah, we're gonna talk about some things that I know my listeners are interested in knowing about. But first, I want to find out what inspired you to become an attorney and what did you do before opening your private law firm?
Well, I can say when I was at Bowie State University, there was a professor that said, you might want to consider going to law school. And I said, okay, I'll check it out. So I did everything I needed to do. And when I was in law school, I was doing what they call the Rule 16 at the time, where you can practice to become an attorney. And at that time, there was a individual that I was representing that was stopped for the smell of marijuana. And the judge found him guilty because they said that you can search someone based off the smell of marijuana. I argued against that. I said, I don't believe that should be the law. This is 2017. Then after that, I said, you know what? I think I need to be a prosecutor because we need to have more discretion on who and what we should prosecute. So after that, I became a prosecutor once I graduated for about 3 years. And then after that, I went into the criminal defense world. But that situation really gave me great pause because I said, well, there's someone here making a decision that I believe if someone that looked like me was had the power, I don't think that person would have been convicted, and he should not have been convicted. It was a nonviolent offense, and it was just for having a few grams of marijuana. And as we know at this time, marijuana is now decriminalized here in the state of Maryland.
Yes, yes. And imagine all of the Black people, Black men especially, that have been incarcerated over marijuana and now look at all of the people that own these marijuana shops.
Exactly. And it was
Yeah.
something that triggered something in me to say, hey, look, this is bigger than me, bigger than what I want. And I wanted to just try to make an impact in the community.
Yeah, great. So who needs a criminal attorney? And what are the first steps people should take if they're arrested or believe that they're under some type of investigation?
That's a very good question. So the obvious answer is when you're charged, right, you need an attorney. However, there are times that you might need an attorney that you might not realize. If you are doing any kind of illegal or you are doing activity that someone might think is illegal, you might want to higher representation because they can help you stay out of the weeds. Also, when you are under investigation, meaning that the police have informed you that there could be charges, we want to speak with you. Anytime you speak to a police officer or anyone else in the legal field, such as the state attorney, you need to have an attorney present. They
Mhm.
protect your rights. They have the opportunity to hear your side of the story and then tell you what you should and should not say. Once you say it, you cannot take it back. You can't say, "Oh,
Wow.
I didn't say that." So, and then that can be used against you in court. I've had so many situations in which I said, if you would have remained silent, I think you would have a different outcome. And so, to
Mhm.
avoid that, having someone that has the experience and the wherewithal of knowing how things work becomes very important.
Yeah, I wonder why people don't know that they should remain silent. I mean, I would think that that's general knowledge, and people should know how important it is. Um, why do you think that is, that they just don't know?
I think they know. I think in a situation, it can get, I guess, how can I explain it? People get excited. Oh, I'm going to tell the police something. They're going to let me go. And I,
Right.
well, if they're going to arrest you, they're going to arrest you anyway. Making a statement to the police is something that nobody should do. I'm an attorney. I'm a criminal defense attorney. I have vast amounts of legal experience, and I do not talk to the police. And
Okay.
when they're asking you certain questions in the moment, you're thinking you're giving a truthful answer or even what you believe is the correct answer. But that answer could very well doom you when it comes to trial, and being in the situation sometimes makes it difficult to know what you should and should not say. So just say nothing at all.
Okay, so Attorney Brownlee, is that what you mean when people speak to the police without an attorney present? Uh, is that the right that they often give up without realizing it when they're interacting with police, that they've given them information that may be used against them because they did not remain silent and they did not have an attorney present? Is that a right they often give up?
Yes, but sometimes the officer never tells them, right? You have the right to remain silent until the arrest.
Oh,
When this normally comes into play is with the standard DUI, right? You
mhm,
get arrested, you get pulled over, and they start asking questions about where you're coming from, how much you had to drink. You do all of these different tests, and then they arrest you at the end. And then they say, "Oh, anything you say can and will be used against you against the court of law." But
mm.
everything that you said previous to that will be used against you in court as well. But they never were advised of their right to remain silent. Okay. Even though they know they have that right because it's all over the place, it's public information. And the officers never force you to talk, but people just for some reason want to tell police more than they need to know.
Yeah. What are some of the biggest misconceptions people have about the criminal justice system?
I would say that people think if you have an attorney that you're going to miraculously get off, or they believe sometimes that the system, believe it or not, some people believe the system is fair. Sometimes people believe that the system does yield just results. They also think that the system works quickly. And I can tell you, really, none of those things are true. Um, People get into a situation and they want it to be resolved instantly, right? They want their trial date to be tomorrow. They want to have a bond review hearing immediately, but things just move very slow, especially depending on what county or jurisdiction that you're in. Also, when it comes to having a case, we can't change the evidence, right? We cannot change things that if you made a statement or if your DNA is at a particular scene and we can't explain that, it's going to make it challenging for any attorney to get you completely off. But attorneys do have a major role in how to shape the evidence, but we can't also change the facts. So when it comes to how the system works, we work well within it, but it is not a system that I would say is friendly to those who are charged with crimes.
Mm. Now, I've always said to people, whenever you go outside of your home, you should dress nicely. You should dress. as if you are the walking, talking billboard for yourself, because you are. And I have been to court on several occasions and have seen people just come in dressed any kind of way, like they just rolled out of bed. They, to me, I believe that a client or witness should present themselves well in a courtroom, and I really do believe that that has some sort of impact on the outcome of their case. Is that true or not?
Well, I think it is true. It's why when you have a jury trial that they make you change into clothes, such as what I'm wearing now, or something at least that's presentable for court, because they understand that how you're perceived makes a difference in the outcome of a particular case.
Hmm.
Not that when people come into court with their pants sagging, smelling like weed, tattered clothing, when it comes to judges, right? Judges are people. They all have different biases and they all process information differently. And if someone is sitting on the fence about whether or not you're guilty or not guilty, the way you look could make the difference.
And that's just life in any circumstance, right? The way
Yeah.
you present yourself, the way you look does, in fact, make a difference. Before we go to break, Attorney Brownlee, tell my listeners how they can reach you. Is there a website? Are you on social media? Let them know.
Yes, I am on Instagram at V as in Victory Brownlee, Brownlee Law. You can also give us a call at 301-502-4441, or you can send us an email at vernon@vbrownleelaw.com. And our website is vbrownleelaw.com. And that's Brownlee.
That sounds great. So when we come back from break, Attorney Brownlee, I want to talk about how having a criminal record impacts people's futures, even for minor offenses. Because a lot of times people think, oh, it was just something minor, or it's no big deal. So we'll talk a little bit about that. And we'll also talk about the systemic bias and racial profiling that shows up in criminal cases and how you, as an attorney, can help protect against it. So I want you guys to stay tuned. We'll be right back after these messages here on Sirius XM Radio, Channel 141, HUR Voices. And we're back here on Skin Deep with defense attorney Vernon Brownley. Um, so, Attorney Brownlee, how does systemic bias or racial profiling show up in criminal cases, and how can you help your clients protect against it?
It shows up in very clear and obvious way.
Hmm.
As a prosecutor now, as a defense attorney, when you look at what we call searches and seizures of vehicles, that means the police pulled you over for whatever reason and they are searching your car, right? And they find a reason to search your car, whether it's they believe what they call furtive movements or the smell of marijuana or something else. Overwhelmingly, the people who get their cars searched are blacks and minorities.
Mm,
And the reason why that is because the police have inherent biases towards people of color,
yeah,
right? I mean, over 80% of people, there was a study done, I think around 2014, 2015, that 80% of people who was actually searched was minorities. And you say, well, how is that the case when 80% of the people driving aren't minorities, right? And so when you have those situations, of course you're going to find more things because you're searching cars more often of people who are of color. Now, once you get past the police stage, then you have the prosecutors who have their own bias of how cases should be dismissed or handled, right? Oh, well, we're going to keep that felony. Whereas on the other side, if that person is connected to the community or they look different, they might dismiss that felony and put it on a completely different trajectory. And also the judges who decide your cases, right? Now, once you get to the judicial part of it, meaning that the judge is making the decision, you are hoping that all those biases are, thrown out the window, but you can never be clear. But the reason or how you even get into the system most of the time is coming from individuals who believe because of the way you look, that you must be up to no good, and they go about doing their job in a different way because of who they're coming into contact with. And like I said, I don't think the numbers are that way because of an accident.
Yeah, yeah. What should families know if a loved one is detained? Like, what can they do immediately to support them?
If they are detained, the first thing they should do is figure out when their bond review hearing will be. Okay, certain counties, sometimes it's the morning, sometimes it's the afternoon, but you want to make sure when their bond review hearing is going to be, because you want to show up for them. Family support at bond review hearings is extremely important when it comes to whether or not the person is going to be released. Because you being present, the judge sees, hey, this is a community. They're going to make sure he's there on time. They are going to support him throughout this process and ensure that this person is at least going to stay on track until their trial date, instead of saying, oh, this person has nowhere to go. No one's here to support them, and I'm going to keep them incarcerated. Then after that, of course, hire an attorney to help assist and make the best arguments for them to be released prior to trial.
Explain what a bond review hearing is.
A bond review hearing is where you have a court proceeding in which the judge is going to say whether or not you can go home prior to trial, or you have to wait in jail up until your trial date. I was just in a bond review hearing today, and my client was released. So that means for his next trial date, his trial date, I think it's in December, he can be out and be at home and take care of his kids um, pending the trial or waiting for the trial. At the bond review hearing, the judge can make the decision to hold you or to say you can't go anywhere until your trial date.
Isn't the bond review hearing tied to a specific amount of money that the judge deems is needed to stay out of jail? What is what does that
Yeah,
have to do with bail? Bail and bond, are they two different things or one and the same?
the one and the same, but bond is the condition that you're going to be released on. So that's on your own recognizance, or what they call ROR, or we're going to trust that you're going to come back, so we're just going to release you. Or they'll put you on some type of monitoring for you to come back, right? Without paying any money. In Prince George's County, they don't give monetary bonds. It's either release on your own recognizance, you are going to be on some kind of supervision to monitor you, or you can be placed on home detention, meaning that you can stay at your home and home only, and then you have to come to court. Now, bail is when, let's say, money is set, right? Say it's $5,000, a person can't afford it. So you ask for that bail money to be reduced so that person can be released. The reason why Prince George's County, or at least what they say, the reason why they don't go down the path of monetary bond is because they don't want people to be released based on how much money they have. They're either too dangerous to be released, or it is safe to release you, and money should not be the reason why you should be released.
Oh, okay, okay. So bail and bond are pretty much one and the same.
Yes.
And bail is an amount of money you need to pay in order to get out of jail. But where you practice in Prince George's, they don't deal with bail. But what about other jurisdictions? Because you practice in the entire state of Maryland.
Yes, most jurisdictions in Maryland are fading away from the bail system. They are more on the pretrial release. So you have pretrial release, private home monitoring companies. Now, these companies do cost money, sometimes between $400 to $600 per month. However, if you don't have the funds, the state of Maryland will pay those companies to monitor you without any cost. And that's because the state of Maryland says, well, it's safer to monitor certain people that we don't believe to be in jail. But we also want to make sure that we're not overpopulating the jails by saying there are no means to release the individuals. So the pretrial release is the happy medium that the state of Maryland has kind of rested on.
Okay. Now, how can someone know whether they're choosing the right criminal defense attorney? Or if they don't have money, they have to go with the attorney that is assigned to them by the courts. Is that correct?
Yes, that is correct. There are two options. If you're charged with a crime that carries jail time, you can have you have an entitlement or you have a right to have an attorney. Okay. Now, if
Mhm.
you can't afford an attorney, a public defender will be appointed to you. You can't choose who that person would be. If you do have the funds, you can hire a private attorney such as myself. Things you should look for is one, is this person personable? Can I talk to this person? This is someone you're going to have to talk about legal strategies, other issues that are going to come up. Secondly, does this person have any kind of local ties to the area? Do they know the prosecutors? Do they know the judges? Can they help with the ins and outs? And those little minute details make a difference, because if I see or I know a prosecutor or a judge that is favorable for our situation, I might, go about handling the case differently. Also, when it comes to scheduling, knowing who to call to get certain things assigned, having a prosecutor who knows or having a defense attorney who knows what is going on in that local jurisdiction can be very resourceful.
Yeah, yeah, that's great information. And before we end the show, I really wanted to talk a little bit about plea bargaining. Like, what role does plea bargaining play, and how can it both help and harm the defendant?
Yes, it is probably one of the most overlooked skills that we have as defense attorneys. Everyone says, "Oh, go to trial," and we want to see you in action, right? It's like almost like a movie, and that's
Yeah,
fine, and that's fun. But plea bargains help our clients because sometimes in cases, well, I would say vast majority of times, there's a lot of evidence that points to guilt to our clients. What plea bargaining allows us to do is say, we understand that the evidence could show this. However, consider these factors. Consider my client's family. Consider that my client has no background. Consider that even though the evidence could be strong, you might have witness issues. So instead of you asking for the top count, can I get a misdemeanor? Or instead of you prosecuting the case at all, can you put it on an inactive docket so there is no prosecution of the case and there's a path to get the case dismissed at a quicker time frame? So those are the things that we always explore when we have any case.
well, when the defendant though swears that he or she is innocent, um and they don't want to do a plea bargain because they know that they're innocent, what happens in those cases, Attorney Brownley?
Well, the client runs the show. So if they say we want to go to trial, you go to trial. Now, before you get to that point, you do go through every single legal avenue, because if I'm telling you that the plea is the best possible option, it is likely the best possible option. They sometimes want to go to trial for other reasons, whether they have ego, whether they just don't want to admit that they were wrong, or whether or not they don't want to look like they're lesser than in front of their peers, or pressure. But I'm like, I understand that, but your DNA is here and there's no
Right.
explanation for it. And you're also on video leaving the scene and your cell phone puts you there. So what do you want me to say to the jury? You go to trial. Right now, I have an opportunity that the state attorney is going to give you a misdemeanor. And if you go to trial, you're looking at 25 years. And this is the evidence. What do you want to do?
Right, right. Okay, listen, Attorney Brownley, the time has gone by really quickly. You've been a great guest.
Yes.
I have to have you back on the show because I think the information that you offer our listeners is really, really important. Tell us again how my listeners can reach out to you.
Yes. Instagram, it is V as in victory, Brownlee, Brownlee law on Instagram. We do follow back. You can give us a call at 301-502-4441. You can also visit our website at www.vbrownleelaw.com. And you can find us just with a Google search of the law office of Vernon Brownley. You can see anything that you want about myself or my firm. And if you need an attorney here in the state of Maryland, hopefully you choose us.
Thank you so much. Thank you so much, Attorney Brownley. That's it for now, folks. I'm your host, Sharon Morton. I hope you take the information we provided today and use it to grow your defense. You can hear this show on SiriusXM Radio Channel 141 HUR Voices on Fridays, Saturdays, and Sundays, as well as on iTunes, Spotify, Stitcher, and all of the streaming platforms. And hit me up at skindeepradioshow@gmail.com if you have a show idea, or check me out at Sharon_Morton on Instagram and Facebook. Thanks again for tuning in on all things that are skin deep.